Okay guys, now I'm going to need you to stay awake for this one, but today I wanted to talk to you about retail shop leases. Hi, I'm Aaron from Onsite Law, and this video is all about giving you some honest insight into the process of leasing a retail shop in Queensland. If you're looking for a cure for insomnia, then try reading a retail shop lease. Seriously, if you're having trouble getting to sleep tonight, grab one of these and I'll be surprised if you're not out cold by page 4. Lawyers will usually start out with a lengthy template to cover every possible situation that might come up during a tenancy. They say to protect both parties, but more often than not, they favour the landlord. The truth is, there are usually just a few key critical issues that are super relevant, whether you're a landlord or a tenant, and we'll go through those in just a minute. So, if you're not asleep just yet, let's talk about the legislation to get some background about what happens when you take out a retail shop lease. In Queensland, we have the Retail Shop Leases Act. Before parties can enter into a lease, they have to do a few important things. First, landlords need to give prospective tenants a lessor disclosure statement. The idea being, this document summarises the critical parts of the lease for the tenant in just a couple of pages. Second, tenants who have less than 5 retail shops in Australia must in return provide a lessee disclosure statement, explaining a bit about themselves, and also obtain a legal advice report from a solicitor, which is where someone like me comes in, and then a financial advice report from an accountant. The idea of this process is to make sure tenants are fully informed and get advice before being locked into what can be a serious, expensive and binding obligation, often for up to 5 years.
First and the left, that's it, that's the way they do it. Strap him up good and tight there.
Okay, so if you ask me, what are the most important 6 things you need to know about a retail shop lease? Here they are. Leases usually start out as a shorter offer-style document, which is more or less an agreement to agree on a more formal lease later on.
I'm going to make him an offer he can't refuse.
This identifies just the critical elements of the lease to follow and is often prepared by a real estate agent or a centre manager. I suggest both tenants and landlords get advice before signing off on this document to make sure those key terms suit them. Although the offer in itself might not be binding, it does set expectations on both sides, which could be hard to adjust later on if you waited until a formal lease was ready to get advice. Rent is usually the most critical element of any lease. It's important to know how much per square metre you're paying and how much this works out to be annually, not including GST. Most leases will then allow for the rent to be adjusted each year on the anniversary of the commencement date.
Happy anniversary.
The most common review types are to the Consumer Price Index, CPI, or to a fixed percentage increase. For example, 4% perhaps. The term of the lease is the next critical element. Most leases will allow for an initial term, for example, 3 years, and then for option periods, which are further terms that can extend the lease if the tenant elects to stay on. If you've ever wondered what it means when someone says the lease is a 3x3 or a 3+3+3, it means there's an initial 3-year term with 2 more 3-year terms available, giving the lease a total of 9 potential years if the tenant wanted to stay that long. Bear in mind that the length of the term can also be a negotiation tool, as most landlords like the thought of having a longer lease in place to give their property investment some security. If options are extended, it's often the case that the rent is reviewed to market conditions at that time through negotiation, and if an agreement can't be reached on that amount, the legislation does have mechanisms for a valuer to decide what that might be. Outgoings are the landlord's operating expenses to run the building or the centre and are often charged to tenants in addition to rent. These need to be disclosed to tenants clearly in the lessor disclosure statement, and tenants should request estimations of what these are before they enter into the lease and make sure these are in the budget.
Believe me, that's all you need to know.
You mean money is the whole thing?
Money is the whole thing.
Most leases will require a bond or a security deposit. More and more these days, rather than cash, landlords require tenants to provide a bank guarantee, which is a fancy piece of paper the bank prepares for the landlord to hold on to as security for the tenant's obligations under the lease. There's no set rule for how much bonds are, but it's common for the amount to be equivalent from anywhere between 1 and 3 months' rent and outgoings. Most leases will require tenants that trade using a company to provide a personal guarantee. This means that the directors or shareholders of a company sign a guarantee and indemnity as further security for the landlord in case there is a breach. Landlords should be requesting these, and tenants also need to get advice about the risks of signing these too. Okay guys, I hope you're still awake and you've managed to learn a thing or two about retail shop leases.